professional, and academician. It is my great privilege to introduce our mentor for today's session, Advocate Manas Mishra sir. He is associated with the High Court of Judicature at Allahabad, Lucknow bench. He holds an LLM in criminal law with a minor in human rights from Dr. Hari Singh Gaur Vishwavidyalaya Sagar and a BA LLB honors from Amity Law School, Amity University, Uttar Pradesh, Lucknow. His research interests include criminal jurisprudence, constitutional law, human rights, international constitutionalism, environmental sustainability, digital evidence, and socio legal studies. He has authored and co authored numerous research papers and book chapters published in reputed UGC care listed and peer reviewed journals. He has also presented research papers at various national and international conferences organized by prestigious institutions such as JNU, BHU, Delhi University, and several central universities across India. Apart from his academic contribution, he serves as a member of the review committee of the International Journal of Research and Analytical Reviews and is associated with the editorial board of the Center for Philosophical Inquiry. His dedication to legal scholarship and practical legal education makes him an ideal mentor for today's session. Sir, on behalf of Team Vidhiyata and all the participants present here, I extend a warm welcome and heartfelt gratitude to you for sparing your valuable time and sharing your expertise with us. Without taking much of your valuable time, I respectfully invite Advocate Manas Mishra sir to deliver today's session on legal notice and drafting. Over to you, sir.
Thank you so much, Soumya, for this introduction. Uh, Thank you so much, participants and team Vidhigyata, to invite me as a resource person here to deliver on such a important topic. So, without any delay, let's begin with the topic itself. Just a second. Yes, please open the slide number 1. Yes. So, there are two definitions which for the purpose of definition we usually refer Blake's Law Dictionary. So many texts we can found, so many research work we can found to having quoted the same. So as per Black's Law Dictionary, when a person notifies or gives notice to another by taking such steps as may be reasonably required to inform the other in the ordinary course, whether or not such other actually comes to know it, it is termed as giving notice. So, from this critical definition, we will try to decipher some important points that can help us to understand the basics, the concept, the interpretation of this Black's Law Dictionary, and another definition according to the Chambers of 20th Century Dictionary 1961, which defined the word notice as it stands for the intimation, announcement, information, warning, or writing, etc. So, notice from these definition we can infer that notice is not simply informing. Notice means simply informing another person about something in a very proper and reasonable way. It is not necessarily that the other person actually reads or understand the notice. From the definition of the, as per Black's Law Dictionary has provided, we can say that it is not necessary that another person to whom the notice is being served, he actually reads or understand the notice. What matters here is that sender has taken all the reasonable steps to communicate the information in the ordinary course of action. So let us understand with the example. Imagine you have a good friend to whom you are supposed to convey a message. So you just convey, you just send him message through WhatsApp or any other form of sending a message, for example postal services, so on his address, and your friend never opens the same, your message has not been opened by him, so can he later claim that I was never informed? There are higher possibility that he can claim so. So legally, the answer is not necessarily. If you have taken all the reasonable steps to communicate the information, the what does the law say? That it considers that you have given notice, even if the other person did not actually read so. I think there is some problem with the audio. Somebody is sending message in the group. Am I audible, class? Hello. Okay, okay, fine.
Yes, sir, you are audible.
Yes, sir, you are continuing. Yes, sir. Okay, okay, fine. Give me just a second. Yes, I was saying that it is not what matters to the sender is that yes. So the answer is necessarily not. So it is important that you have taken all the reasonable steps that is required according to the law, and the law considers that you have done your job, you have given notice. So even if the other person does not actually read or not that or read or not read doesn't matter. Please change the slide. Yes. Next, we have forms of notices. So first we have a statutory notice. So let us first understand the same. The word statutory means something that is required according to the statute or any act that has been passed by the parliament. So whenever a law specifically says that before filing a case or starting legal proceedings, you must first send in the notice. That notice is called statutory notice. Uh, Simply, if we can say that there are certain enactments, certain acts, certain laws, for example, Code of Civil Procedure or Partnership Act, we will be looking at the provisions in the upcoming slides, which requires that the notice should be sent before initiating any legal proceeding, and it has to be complied with. It is an important step that has not to be missed out at any cost. So, whenever a law specifically says that before filing or initiating any such notice, you must you have any proceeding before the court of law, you have to send a notice first, and such notice is called a statutory notice. So, a statutory notice is a notice that law itself requires a person to send before taking any legal action. Further, we can classify the statutory notice in two further classifications: mandatory notice and directory notice. So far as mandatory notice is concerned, I hope I am not very fast. Uh, Mandatory notice is a notice that must be given before initiating any legal proceeding. So think it as a first step or initial step or a legal prerequisite. So without fulfilling this requirement, the court may even dismiss your case. It may not entertain your case because the provision that requires a notice to be sent before the initiation of any legal proceeding has to be complied has not been complied by the advocate. So, for example, suppose there is a provision in Code of Civil Procedure that before filing a suit against the government, you must give a 2 month notice to the uh, government. So, if you file the suit without giving that notice, your case may be dismissed because you have not complied with the legal requirement. These provisions have very deep significance because, for example, if you are initiating any proceeding before the government. Usually we see in administrative cases that most of them are usually against the government for seeking remedy. So maybe in case you have complied with this notice procedure, there are higher chances that your this issue will be resolved, may be resolved before taking any before initiating any legal proceeding before the court, so as to seek the remedy. So it is very important to comply with the provisions that has been made compulsorily to be followed by the uh, advocate and the client. So, uh, so remember one thing, that a mandatory notice is compulsory. Without sending, without complying with the provisions that has been made in the law, any sort of legal action may not be taken, may not be entertained before the court. Next bifurcation that we can see is the directory notice. Directory notice, yes. So there's a very famous thing we can say, that every mandatory notice is a statutory notice, but necessarily every statutory notice is not mandatory notice. Now let us understand this thing. Suppose uh, um, a directory notice is also provided in a statute, but it is not required to be complied with, because it is not mandatory notice. The many a times provisions mentions that it is mentioned in the provisions that it is in the directive form, it is in the mandatory form. Usually we infer these things applying the principles of interpretations also. So if the notice is not given, it does not automatically make the legal proceedings invalid. So where there is a requirement, it is mandatory notice. Where there is no requirement, it may be called as a directory notice. It completely up to you whether you serve the notice or not. But there are pros and consequences of serving a notice and not serving a notice. Serving a notice is always beneficial for you. For example, if we take section 206 of the Indian Contract Act, so which says that a principal should give reasonable notice before revoking any agency. If in case no notice has been given, no notice has been made to the revocation may still be valid, but the other party may claim compensation for any loss that has been suffered due to absence of notice that was supposed to be served, but not mandatory. It was completely up to the party that whether it serves the notice or not. So the key idea here we can infer is that a directory notice is desirable and expected, but not an absolute legal requirement for initiating any legal proceeding. I hope I am clear with the statutory notice. So let's begin with the next form of notice, public notice. So, as the name suggests here, is the public notice, which simply means that it is meant for the general public or a larger group of people who may be affected by a particular decision, particular event, or any sort of legal action. So, simplifying it, we can say that it is a notice issued to inform the public at large about a matter that may affect their legal rights, interest, or any legal obligation. Since it is impossible to personally serve the notice where the interest of large person or large people or group of people is concerned, so law permits that such notice to be published through newspapers that has wide circulation across the area or across the state where the so many populations have been covered, or it has to be published in an official government gadgets. So in once it is published in these recognized modes of serving a notice, the notice is produced, the public is presumed to have known, have been informed about the fact that public has to be known. For example, generally we can encounter in newspapers or uh, other online things as the technology has advanced. So, if a person intends to sell an immovable property, or it dissolves any firm, or there is auction of any property, or where there is a termination of any agent's authority, so a public notice is generally issued so that anyone having any interest or any objection, they can come forward to seek any interest that they are associated with the same. So as I was discussing earlier, that certain statutory mandatory things are required to be complied with. We can take a very good example of Indian Partnership Act 1932, where minor who has been admitted to the benefit of the partnership, but according to what section 30 clause 5 requires, that he has to state whether he chooses to become a partner or not after attaining his majority. So he has to get it published in a official government gazette or newspaper, that usually newspaper, that he has attained the majority and he will be continuing with the partnership thing. Similarly, while dissolving a partnership firm, so it is mandatory that according to section 45, you can take another very good example, that it requires that there should be public notice to be served regarding the dissolution of the partnership. So, concluding with the public notice, we can say that public notice is not issued to any particular person. There are large number of persons that are involved. uh, it has to be served through a recognized public media so that everyone who is associated, who is affected, gets an opportunity to know about the legal action or any sort of event. Next classification is the private notice. So, so far as private notices are concerned, these notices are addressed directly to the party who has either committed such breach or is likely to be affected. For example, uh, suppose there is an appointment of arbitrator. So a notice has to be served to other person whose interest is also involved, so as to resolve the issue. There is a notice by the landlord to tenant to quit the rental property, or claim to a debtor from the creditor, that money suit may be filed against him if he will not comply with the notice. So there may be some kind of wrong that we can encounter, for which compensation is needed, maybe for the defamation, civil wrong for defamation thing. So for these private matter where two individuals are involved, or where a very small group, two, three people are involved, and where mediation, arbitration things are uh, going to take place, arbitration thing. So it must be served individually. Next, we have actual notice and constructive notice. So, as the name suggests, that actual notice means that a person has direct knowledge of a particular fact because the information has been communicated to them personally, either orally or in writing. So, it simply means that the person has actually been informed about the fact directly, and further they have to comply with the thing. Actual notice has been defined in the Blake's Law Dictionary as the notice that is expressly and directly communicated to the concerned person. For example, like we have discussed in like for example, there's a if a landlord personally hands over an eviction notice to a tenant, or send it through the email or registered post. So the tenant has, you can say, that actual notice. And further, actual notice can be classified in two forms: express actual notice and implied actual notice. That we do not necessarily go into deep. So we can take one small thing to remember that actual notice means direct knowledge of a fact either through explicit communication or through circumstances that clearly establish such knowledge. Next, we have constructive notice. In case of constructive notice, what happens is that a person is not served any sort of notice like orally or written form, as we have seen in other cases. So, what is the law here? Is that the law itself presumes that they know it because the information was available and they could have discovered it by exercising ordinary care and diligence. So it is considered by law that a prudent man would have knowledge about the same. So we can say that constructive notice is a deemed notice that law treats a person as having knowledge of the fact, even if they did not actually know it. But here it is a presumption by the law that the concerned person, associated person relating to any dispute, they have fully aware about the fact. So, for example, we can take a sale deed is registered. Everyone dealing with that property is presumed to know that about the registration process that cannot be missed. Similarly, any sort of pending suit, less pending thing in TPA we see is treated as a constructive notice to persons dealing with the property. Next, please change the slide. Modes of service. Ashutosh, please change the slide. Yes, modes of service of a notice. So there are certain modes that has been recognized according to the customs, according to the conventions, according to the statutory laws that requires that it depends upon completely it depends upon the nature of the case and applicable law that what kind of mode has to be adopted in a particular situation. So first, personal service. We have so many things discussed about the personal service. So usually in this case, personally, the parties who are involved, they personally deliver to the addressee, and the person received it, and it is considered as the most convenient form of personal service mode of services. Next, we have a service through post, the most reliable form of serving a notice through the post. So, and it can usually be encountered with the registered post with acknowledgement due or any other recognized postal modes like Post India or any other convenient, reliable method that can that can help in sending a notice from one place to another place. So, if the notice is correctly addressed and it has been sent to the registered post, the law generally presumes that it has been duly served. Next, we have a statutory or prescribed mode of the service. As earlier discussed, that there are certain statute that specifically mentions the same that such kind of notice should be served in such form by such mode. So, for example, a notice under Section 80 of the Code of Civil Procedure, which states that the notice must be served upon appropriate government authority in a manner prescribed by the law. Next, we have service by implication, that is known as also known as deemed service. Sometimes what happens that the receiver does refuse to accept the notice. So in such situations, the law treats the notice as having been served, and because a person cannot avoid legal consequence simply by refusing to receive it, this is known as a service by implication or deemed service. Next mode of service is special mode of service. So in exceptional circumstances where ordinary service is not possible, the law permits special mode of services. For example, affixing the notice on the conspicuous part of the address. You do not confuse with the provision for the absconding offender in case of CRPC. However, the thing are the same. Or business premises may be treated as a valid service. For example, any person who is involved in any case or dispute, he has certain business thing and he is not available at the home, so his business place is considered as a most reliable places where notice may be served. So it is an exceptional, considering it as a exceptional circumstances, this special mode of service can be adopted. Please change the slide. Yes. Hold on. Yes, there are drafting of legal notice thing. So very important part of our discussion today. This theoretical part we have covered till here. Now we are moving towards the drafting of legal notice. So just give me a second. I hope yes. So it talks about the first and foremost what requires is that uh, relevant facts and documents has to be collected by the advocate from the client, and a notice should never be drafted without understanding the complete fact of the cases. So as the first rule, we have so many things discussed in our that has been discussed by Dr. Mudra Singh also in our first session about the same, that we must be aware about the facts and circumstances of the fact so that we can move further without any issue or problem that can encounter, maybe not at the time of the serving notice or notice time, that may be an issue and hurdle hindrance during the court procedure if the purpose of notice is not served. Is not served. So all the facts and relevant facts and documents has to be collected from the client, and to it must be complied with. Next step is to identify the legal issue involved. Uh, First and foremost, we should hear all the relevant issues. The client counseling things first come, and at that stage we can encounter so many legal issues that are involved. We must understand those issues, and then we must apply the law or the remedy or the thing that can help him to to deal with the case at very earlier stage. For example, the purpose of notice should be served that the purpose of notice is also that it should not lead to the litigation. So, having properly recognized the legal issue, we can make the good with the client. Third is the understand what the client wants to achieve through the notice. So it may be recovery of money, performance of contract. It may be compensation for any wrong that has been done, or it may be for stopping any sort of illegal activity, illegal act that has been taken place. Next rule says of step 4 is that this first, second, and third thing uh, has to be learned properly. That there should be proper collection of all the documents, a proper collection of all the relevant facts, then recognizing the issue that is legal issue that is involved, and third, to what does the client wants from the other party. So these things should be properly ascertained by the advocate in order to proper draft a legal notice. Because until unless we are not, advocates are not well aware about the fact and circumstances of the case, it will not serve the purpose. It will not serve the justice with the client. No. So now starting with the some practical aspect. 4-5 points has to be properly taken care of. The first is facts should be presented chronologically and preferably in number form, numbered paragraph. So accordingly, each and every issue that is necessarily has to be put in the notice. Last time I remember that one student from the participants asked about the emotion thing. So emotion things does matter, but it has to be complied with the law. Whether and for example, if there is complete a case of mental harassment thing, so it heavily involves the emotion thing. So we must comply with the law. What does the law say? Then we should consider the thing where it has no nexus with the law. It has to be it is required to be avoided. There is no need to mention anything that is irrelevant, that may not affect the party we are approaching to seek remedy. That our concern, the purpose of notice is to serve the to seek the remedy at a very earlier stage, and the issue will not lead to litigation thing. So we must comply with this. So chronologically, all the facts has to be mentioned, all the remedy has to be mentioned, what can be the consequence that we will further deal with has to be mentioned in a notice. Then we have a name and complete address of the both parties, sender and addressee. So the notice must have a complete address of the parties involved, the sender and the receiver. Then it should clearly state the cause of action arises, or relief or demand that is being made by the party which has approached the advocate for the same, and what will be the reasonable time for the opposite party to comply with. For example, 5 days, 10 days, 30 days, whatsoever it is. It has to be There has to be some reasonable time that should be provided in the notice, that the other party get opportunity to comply with the same. Next is the notice. Next is notice should also mention the legal consequence if the demand is not complied with within the stipulated time. For example, there in notice it talks about that 5 days period or 10 days period or 30 days period that has been given. Chance has been given to make the things good. But in case within this stipulated time the remedy is not sought, then there may be legal consequences. So it is the duty to mention all legal consequences that may arise. For example, it may lead to litigation. So what litigation it may lead to, it has to be mentioned. And finally, it must contain the date, place, and mode of service, and signature of the sender or the advocate. So date has to be mentioned, a place has to be mentioned, and mode of service must be mentioned. So these these 3 points has to be really clearly understood and recognized. The legal issue, uh, the legal issue thing, and all the relevant facts and documents necessary, and understand what the client wants, what he seeks from the other party. And then all these things, the chronological order of the facts and circumstances must be clearly recognized and properly put in a notice thing in a numbered paragraph. So please change the slide. Reply to the notice. Yes. So reply to a notice, as it is written here, every legal notice should be replied to promptly and carefully. For example, here you are not supposed to send a notice, but you have received a notice. So it is there is no need to worry about this thing. You must reply to the notice very carefully and promptly, without making any issue, without anything. For example, that you have received any notice, so it is your duty to follow all the things that we have discussed, thinking about the perspective of the person who has sent the notice to us. So we can say that reply must always be made, because in case any sort of litigation takes place further in future, it will help to get you out. You must all the claims that have been made by the other party who has sent the notice, you must uh, either if you have genuine answers for the same, so then you must send them the required thing, required document, required evidence, and your sentence must be corroborated with the same. So this is the end of the theoretical part, and some glimpse of the drafting that is necessary, that has to be taken care of while drafting a notice. Now I would like to show you some examples of the legal notice according to particular laws, statutory or personal things. So I would request admin to share me drafts so that I can make participants understand the same. Yes, just give me 1 second, please. Yes. So here is a problem related to a notice under section 138 of the NI Act. So what the background information here is that there is Mr. Ravi Kumar, who is a trader residing at house number 35. The address has been given. Then his office at the office place has also been given, and the value of the goods purchased is. Okay, that was not supposed to be done. Just a second. We which draft I am supposed to deliver here? This one has to be discussed, or another one that was being read?
Whichever you like to so
This section one.
would you like to first
106 of the,
introduce the section 106 of the TP or the negotiable one?
I would like to take
Negotiable.
Negotiable, okay.
negotiable. Yes, yes. Perhaps the other documents are for the purpose of their understanding and their homework also. Yes, that I was discussing, that the background information has been provided here in this problem as the same. Then the transaction details have been mentioned, date of purchase, this invoice number, and description of the goods. Payment agreement has been there, that Ravi Kumar agreed to make payment through a check issued in favor of Suresh Patel. Then check details have been mentioned. Please scroll down. Yes. Next, we have incident of dishonor. There is a dishonor of check thing. So Suresh Patel have had deposited a check in his bank account at Bank of Baroda, Kota branch on 27th of June 2024. However, 2nd July 2024, Suresh Patel received information from his bank that the check has been dishonored due to fund insufficient in the account of Mr. Ravi Kumar. So here the the first principle, that all the relevant facts has to be recognized and considered. So we are here with this paragraph, we are here, we can infer the relevant fact. The what may be the relevant fact? First thing is the date, that the check has been deposited on this date, and the another date where on which Mr. Suresh Patel has received information, And the cause of action here it is mentioned, fund insufficiency in the account of Mr. Ravi Kumar, who has issued a check on the name of Mr. Suresh Patel. So, what subsequent actions are there that Suresh Patel immediately informed Ravi Kumar about the same, about the dishonor of the check, and demanded the payment. Mr. Ravi Kumar, what he has done is that he has acknowledged the liability but failed to make the payment despite repeated requests. Please scroll down. That the no no please scroll up. Yes, this is the last paragraph. Let me read this. Mr. Suresh Patel now intends to initiate a legal proceeding under Section 138 NI Act of 1881, and he requires a legal notice to be issued to Mr. Ravi Kumar, calling upon him to pay the check amount within 15 days. So here, this thing that stipulated time should also be mentioned, that we can also infer from this paragraph, and the what may be the consequence if the notice thing that has been something, a remedy that has been sought in the notice directly from the opposite party without making any sort of litigation. uh, so it is the 15 days period has been provided to comply with the same, and failing to which will result into appropriate legal action, and it shall be instituted against him before the competent court. Please scroll down. Yes. So as so far we have discussed so many things in detail about the three principles that has to be recognized while client counseling thing, while listening to a client. So, and other things that we have certainly came to know about the same. The first is the name and address of the parties, brief facts, check number, date of check, that I have already mentioned that these things are relevant facts for for the purpose of sending notice. Date on which the check was presented and the place where the bank situates, date of return memo, the reason of dishonor of check, that is our cause of action, and the stipulated time by which the opposite party has to be complied with the same. Please scroll down. Yes, all these things must be taken care of before drafting any legal notice. So now we are here dealing with the drafting part. So first thing that we are supposed to mention here is the sender's address. Who is the sender? Mr. Ankit Mishra, who is advocate on behalf of the party who has approached him for the legal notice to be served to the opposite party for seeking the preliminary requirement for a preliminary remedy. So Mr. Ankit Mishra has sent notice to Mr. Ravi Kumar. The proper name has been mentioned about the both of the both parties. The place has been mentioned where the chamber of the Mr. Advocate situates, and the place of the opposite party. Please scroll down. Yes. Yes, yes. So subject mentioned here. Please show me the complete document. Yes, 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 fine. That is fine. Subject here is subject as the here it is legal notice, not any sort of print being filed here or any sort of some suit is being filed here. So legal notice under section 138 of the NI Act 1881. So all the facts must be mentioned. We are supposed to remember that all the things, relevant facts, and other details must be arranged in a chronological order, and in a numbered paragraph. So one by one, we will be reading this and ascertaining and corroborating with the discussion we have done so far. So very respectfully, he has been addressed that under the restrictions from and on behalf of my client, Mr. Suresh Patel, who is proprietor of this business Association, and that is situated here. Mr. Advocate hereby serve upon him with the following legal notice. And now, one by one, things have been mentioned that my client is engaged with the business of supply of construction material, and in the ordinary course of business, certain purchases have been made, cement bags, TMT steel rods, and construction tools from his client. So about the fact has been mentioned that there has been certain purchases from the by the concerned party here, from the opposite party. Next, we are dealing with the next paragraph here deals with the paragraph that is also relevant for our discussion for the purpose of notice, relating to the question we have is that there has been issuance of check bearing this number, dated on this, and it has been drawn on Punjab National Bank Jaipur for the amount 4,75,000 in the favor of the client. So another important relevant fact we have done here with next is the that my client presented the said check with his banker, Bank of Baroda, Kota, for encashment on 27/6/2024. So you can see that all the facts have been properly complied with, has been properly put at its place where it has to be. So next paragraph states para number 4, the cause of action thing. Then the said check was returned unpaid with the remarks of funds insufficient. White bank return memo dated 2nd July 2024. Next paragraph states that my client came to know about the dishonor of the said check on the same date, and that your above act you have committed an offense punishable under section 138 of the NI Act 1881. So here we are little bit putting some kind of legal action that may be initiated against him in case he does not comply with the said notice and does not do the needful within the stipulated time. So now the remedy things comes into place. So accordingly, through this legal notice, the opposite party has been called upon to make payment of 4,75,000 along with the applicable bank charges to his client within 15 days from the date of receipt of his notice. Failing to which, the client shall be constrained to initiate appropriate civil and criminal proceedings against him at the risk as to cost and consequences. So here the remedy is being asked within it is expected to be complied within the 15 days within the stipulated time that has been provided by the advocate with the discussion on with which the party is comfortable that for the payment of 4,75,000 must be made. So there is demand of money in lieu of the purchases that has been made, and by reason of cause of action that is fund of insufficiency of fund in our case. Please scroll down. Yes. So hereby it is requested that to take the notice seriously and accordingly, and at last the name of the advocate has been written again, and the copy of the notice has been put in the record, and it has to be signed also. However, there is no requirement of sign, and it's the hypothetical document. So I have been able to make you understand all the things with the theoretical aspect that was necessary to be discussed before the before showing you dispelling you the actual legal notice things, that there is no hard and fast rule. You guys must be remembered about the discussion we have had in our previous class about the basics of civil drafting. So the purpose of doing that session was that it's a very common thing that you must comply with the same. The language, for example, so far as language thing is concerned, so uh, there are so many people. Uh, they are connected from the northeast. They are connected from the south. We people are from the central India, North India. So there is a language thing. So, for example, anything that is associated with the High Court or Supreme Court, so it has to be sent in English only. So far as district courts are concerned, lower courts are concerned, and civil courts specifically are concerned, usually in our northern states, the things are usually done in Hindi form. So, and because people here, मतलब there is huge population of Hindi people, people speaking Hindi. So it is most reliable, most convenient for them to understand what has been written in a notice, what has been there, what remedy has been asked. Same thing as there have been certain visits to Karnataka High Court and some courts of the south also. So I have seen in district courts that several things are being made in a local language. So it has to be complied. The language thing is a very important, and the purpose is to make the opposite party understand what wrong has been committed by him and what legal consequence may be initiated. And ultimate purpose of doing all these things is to not lead to litigation process. Do not falling into litigation process and serving the justice at a very initial process of the at very initial state. Unnecessary putting burden on the judiciary to by giving him another case, and it involves so many costs litigation usually, as most of us would have usually daily basis they encounter that it costs very much. There is a it, there are so many things that we have to encounter during the litigation process. So it is necessary and advisable to the clients that all the things must be resorted before going to going to any competent court. So please show me the other document that contains so many drafts for the this legal notice thing. Yes. So, as I have already discussed, that there are certain forms of notices: public notice, private notice, personal notice, and public this constructive notice. So it depends upon the case and circumstances, facts and circumstances of the case, that what sort of notice has to be served for seeking any sort of remedy or informing the other party about the wrong, about the thing that he has committed, or about anything that he must be known of. So, uh, for example, we have discussed 138 and 9. Now there is notice under section 106 of the Transfer of Property Act. Another, so another we in this document we have 2 3 other notices that has to be statutory notice that has to be done accordingly as the law suggests to be complied with. So this is a compile of one. This is a compiled document of 120 pages that you will be getting at your email after the completion of this program. So now I am open for the discussion part. The um, now I am done with my part with this discussion. If there is any issue, any doubt, you can ask me in the chat box, or if the admin permits, you can open up your mic. You can. I hope I
Thank
have
you so much,
only.
sir. Thank you so much, sir, for such an insightful session. Your explanation of the concept, structure, and practical aspect of drafting a legal notice has provided a valuable learning to all the participants. The drafting exercise was particularly beneficial in helping participants understand how legal note drafting is carried out in practice. We sincerely appreciate your guidance, expertise, and valuable time. Now, we shall proceed to the question and answer session. Participants are requested to post their questions in the chat box.
I would request everyone to let me the questions because, for example, there is a question that can a civil court be filed in a so usually code of civil procedure prescribes that a suit should be filed before the court of civil court only, but where the matter relating where there is a pecuniary jurisdiction where the matter exceeds the money thing exceeds where the money involves around the property value or claim around claim exceeds, so it can be filed before the high court. Law says mandatorily about the district court about filing of the claim. Next, we have is it important to put the heading in the capital letter? Uh, it is usually not required, but it gives certain impact that if you have put certain things in capital letter, so it poses certain some kind of impression upon the other party. Otherwise, it may be relevant, may not be relevant. Uh, Suit filed directly in the High Court or District Court. Suit is generally filed in the District Court, but where the amount exceeds, it can be filed before the High Court. Usually, in money matters, money things where it involves money issue, then it can be filed before the High Court. Is the para under the instruction of my client written as I am unable to understand the question that has been asked by Mr. Vishwendra Pratap Singh. Is it necessary to send a legal notice in every civil suit, or it depends on the suit? It depends upon the suit. As wherever like we have discussed a statutory thing, if it involves a statutory thing, then it must be sent. Otherwise, the court sends like for example, there's a process of serving the copy of plaint. So once it is plaint is served to the other party, then it gives time to file the written statement by the other party. So it automatically comes to the known of the other party. Should we include the litigation charges since it is not legally paid by the parties? Please elucidate on it. For sure, many advocates do the same, that they ask for the charges before for serving the notice also. and most of the time it is also involved. If the case proceeds, though, they can fall pity upon you and they can leave you. That notice will be served accordingly, as you have already paid them the meeting charges also. Private notice and actual notice both are given to the directly affected person. Uh, Private notice is given to the public, given directly to the party that involves, for example, the appointment of arbitrator I have discussed. And for example, where there is a actual notice thing, the person has direct knowledge about the particular fact. So uh, it may be communicated, it may be, or that you must, there is no difference between it. The basics, the classification of both the things can be according to the, on the basis of different heads. That actual notice can also be personal notice can also be a actual notice. Next we have the difference between legal notice and drafting. There is no difference between legal notice and drafting. Here we are dealing with the drafting of the legal notice only. Actual notice is served to the person directly, and in constructive notice, it is presumed that the other person has the other person is known about the thing. There is presumption that take place. No, law student is not entitled to draft a notice and send on his behalf. If you are very curious to draft a notice, you can approach any internship program under any advocate. They can help you to draft a notice and it can be sent to them. It can be sent on their heads. I hope I'm done with the topics with this doubt thing. So I would request that if you have any other issue, then you can mail me also on the.
Okay, participants, I think everyone's doubt has been cleared. Now, thank you all for your active participation and thoughtful questions. Now, as we come to the conclusive part of today's session, I would like to invite Mr. Jahan Soni to deliver the vote of thanks. Over to you, Jahan.
Good evening, everyone. On behalf of VIDHIGYATA, I sincerely thank our esteemed speaker, Advocate Manas Mishra sir, for such an insightful and practical session on legal notice and drafting exercise. Your guidance, practical examples, and valuable insights have made today's session truly enriching for all our participants. I also extend my gratitude to everyone who joined us today and to the entire VIDHIGYATA team for making this session possible. Thank you once again, sir, for your valuable time and support. We look forward to learning from you again in the future. Have a great evening, sir, to all participants.
Thank you, Jahan sir, for your kind words. Now, before we conclude, I would like to remind all the participants that a practice sheet for Drafting a legal notice will be shared in the group shortly. All the instructions will be mentioned in the PDF itself. Please draft the legal notice as per the given instructions and submit your work to your respective team head within the prescribed deadline. Now, I would also like to point out that the recording of today's session will be uploaded on the official VIDHIGYATA YouTube channel within the next few hours. Participants are requested to subscribe to the channel and stay connected with us through all official communication platforms for updates regarding upcoming sessions and opportunities. Once again, we extend our sincere gratitude to Advocate Manas Mishra sir for delivering such a wonderful and practical session. We